the role of an executor. I'm Bailey Kasum, an investment advisor at the Terrace branch here. I'm joined by Alyssa Mitha, Director of Tax and Estate Planning from Mackenzie Investments. This webinar will be recorded and available for viewing at a later date. And we will have a question and answer period at the end. So if you want to just throw any questions that come up throughout the presentation in the chat, we can get to those at the end for you. I just want to firstly acknowledge that Northern Savings is situated on the traditional unceded lands of the Haida Nation and the traditional territories of the Tsimshian Nation. We are committed to taking real action in our journey to reconciliation and have implemented the calls to action for business as outlined by the Truth and Reconciliation Commission. I just want to introduce our returning guest speaker today, Alyssa Mitha. She is the Director of Tax and Estate Planning at Mackenzie Investments, located in the Calgary office. She works primarily with the sales teams in Alberta, British Columbia, and Saskatchewan, providing support to the lead of sales of Mackenzie and company-related products and services. Her expertise is in the area of estate planning, and she assists advisors with any tax and estate planning inquiries. Prior to joining Mackenzie, Alyssa worked at a national leading trust company in a similar role. She has also previously worked in private practice as an estate planning and probate lawyer. Please welcome Alyssa Mitha.
Hi, everyone. Thank you so much for being here. I'm just going to pull up my deck so that you can follow along with the slides. Sorry, give me 1 sec. Are you guys able to see that okay?
Yeah, I can see it.
Okay, perfect. I can't see you, so if there's any issues, just let me know. But today we're going to be focusing on the role of the executor, and this is one of my favorite topics to present on. We talk about estate planning all the time, and often you'll know if you meet with an estate planning lawyer and you're going over your will instructions, they might briefly talk about the role of the executor. So they'll ask, who do you want to appoint? And they typically say you should be appointing someone that you fully trust and someone that's financially savvy. And while those two things are true, the role of the executor is actually quite complex. A typical estate administration requires an executor to complete between 25 to 30 tasks. And oftentimes when an executor is stepping into the role, they don't actually know what's involved, and it can be quite confusing and troublesome for them. So today we're going to be talking about what exactly an executor has to do. And the idea here is that when you look at your estate planning, you'll want to look at who you've appointed, and you'll want to ensure that they are the appropriate person to fulfill the role. The other thing you'll want to do is ask them, right? So if you've appointed them, you should be having a conversation with them and letting them know that you've appointed them, asking for their permission. And if they're unsure about what the role requires, sitting down with them and kind of going over that. We have a checklist that we can provide to you as well, and it might be a good idea to sit down and take a look at that checklist and go over it with them and just ensure that they are able and willing to act. So as far as what an executor does, the first thing that you want to keep in mind is that this role does not come into effect until the individual has passed away. So if you are incapacitated, your power of attorney can step in and make any financial decisions on your behalf if you have that document set up appointing that person. But the executor actually doesn't come into play until the individual has passed away. For the most part, whoever you've appointed under your financial power of attorney is the same person you're appointing as your executor. That's not always the case, but most clients are going to go that route. But that role does not step in until the individual has passed away. And I get a lot of questions on who can be appointed. You can pretty much appoint anyone who is over the age of majority and that is willing and able to act. And you might choose to appoint one person, or you might choose to appoint multiple people. And it's really just going to depend on your situation. So if you appoint one individual, that person is making all of the decisions, and it can be nice, right? They don't have to ask anyone for their opinion or their advice. And they're just able to handle everything on their own. But it can be difficult, right? Being an executor, especially if you've never done it before, is quite challenging. There's a lot involved. So maybe a client wants to appoint multiple people so that there's a bit of a check and balance there, and then they have that support and they can help one another. But if you're appointing 2 or more people, all decisions have to be made unanimously. So if you have two people that don't get along or are disagreeing on decision making, it can really hold up the estate. Some clients will choose to do a majority rules provision. So let's say you have 3 people appointed. If 2 of the 3 agree, that's the decision that goes. And that can be beneficial in some circumstances, right? If you have one executor that's really difficult and is not able to be agreeable to many things, if 2 of the 3 agree, then with that majority rules provision, that's the decision that goes. But if 2 siblings get along really well, they could potentially administer the whole estate and not include that 3rd sibling. So you want to be careful there. For the most part, I think it's usually safe to appoint one person, and you want to ensure that you have backups named. So you can appoint one individual and then have 2 alternates just in case that person is unwilling or unable to act, right? You never know. There could be a situation where your child predeceases you, so you want to ensure that you have alternates named. It could also be a situation where perhaps an executor is agreeable to act at the time you ask, but once that client passes away, what happens in that situation, right? Your executor could be living a completely different life. Perhaps they have moved out of the country, they have, a business, maybe they have a family now. They're not in the same circumstances they once were. So because of that, you don't know where they're going to be in their life. So you want to ensure that you have backups. Now, you are also able to appoint an entity like a trust company that can act. And a trust company can be a really great option because they have trust officers, oftentimes who are lawyers, who just do this job day in and day out, right? So they know how to administer an estate. They're very efficient. They have resources to go to for any tax advice and things like that, all in-house. So it can be a good appointment. Usually when you're working with a trust company, they'll require that a number of clauses be put into the will. And oftentimes you'll notice there'll be clauses in there with respect to investment management. You are always able to work with a trust company and say you're not agreeable to some of the language that's in there. For instance, if you want to keep your assets with your advisor, you are able to work with a trust company and have that language altered, right? So you're getting advice from your lawyer. You're also indicating what you would like and working with a trust company to ensure that they're going to accept the appointment, but that you're satisfied with the language that's being included in the will. Now, if an individual passes away and doesn't have a will or fails to appoint an executor in their will, the province will determine who has the first right to apply. So typically it's your spouse or common law partner, and then kids, and so on and so forth. But at the end of the day, you want to have control on who you are appointing. So it's really important that you have your will in place, and that if you do have a will, it's actually appointing an executor. I would say for the most part, this isn't an issue. It's one of the first questions your lawyer is going to ask you, who do you want to appoint? But I have seen wills where this has been missed. So as far as the duties of an executor, we'll be going through these in detail, but you might have heard of the term executor's year. And typically they say that an executor has a year to complete the state administration tasks, and that terminology has come up in case law. But the reality is these days, oftentimes it takes months before we even get probate approval from the court. And so it oftentimes takes more than a year, but typically you want to try to get this estate administration done as soon as possible. I would say an average estate administration is between 18 to 24 months. After a year, though, the beneficiaries can really start bugging the executor to get more information and see how things are moving along. So whoever you're appointing as executor needs to kind of get this done in a timely manner. Life gets busy, but they have to kind of put this at the top of their priority list. Otherwise, the beneficiaries can start bugging them about that estate administration. And I mentioned the term probate. So probate is essentially the process where the court is reviewing the original will and ensuring that it's valid, and then they grant the executor with a certificate that essentially allows them to act. So if you think about it, let's say I passed away and I've appointed my sister as the executor. If she was to go to the bank and say, my sister has passed away, here's the original will, here's the death certificate, I need the money that's in the bank so I can distribute it in accordance with the terms of her will. The bank's going to say, well, we don't know that this will is valid, right? And they don't want the liability, so they're not just going to release the proceeds. So this probate process exists so that a court is reviewing the original will, and then they're giving the executor that certificate, which takes the liability off of the financial institution or lawyer, whoever's transferring that asset, because they've received the certificate or they've seen the certificate from the court. And we'll talk a little bit more about probate in a little bit here. The second thing is keeping a dated record of everything and all expenses incurred, right? So most of the times when your executor is acting, they're going to be reimbursed for all of the personal expenses that they've incurred. So record keeping is important, right? You're going to be giving your beneficiaries what's called a passing of account. And so they're going to review all of the financial transactions that have taken place within the estate. So they'll want to see what expenses you've incurred. And then one of the next steps is arranging for the service and disposition. And this can actually be a really difficult task, right? So it's obvious that an executor has to take care of the funeral, but if the client hasn't had conversations with their executor, whoever they've appointed, about what they want, it can actually be quite difficult, right? So if you think about it, if you passed away suddenly, you've appointed your kids to act as executor, they have no idea what you would have wanted, they're grieving. It can be quite difficult to plan this. So you do have a couple of options when it comes to that. You can always pre-plan your funeral. You can leave some language in your will that says what you would have wanted, or you can, just have that conversation. Some clients don't want to have the conversation right now, so they do what's called a letter of wishes, and they write it down on a piece of paper and keep it with the will. But that's important and something that you want to think about. And then they have to obtain multiple copies of the death certificate, because pretty much every financial institution, the courts are going to look for this death certificate before they're able to do anything. Just pull up all of these points here. So locating the original will is really important, right? So really, we can't do anything. We can't apply for probate without the original will. The courts assume that if they can't locate the original, it's because it's been destroyed. And so it's really important that you let your executor know where you're storing the original. BC does have a will registry, but it's not often accurate, right? There can be issues with that because you have to pay a fee. If you decide to get a new will done and you don't update that registry, it can cause issues. So it's definitely a helpful tool. But it's not like a be all end all, right? Your executors do need to know where you're storing the original will. They need to be able to actually obtain it, whether it's in your safety deposit box, whether it's in a safe place in your house, whether it's at the lawyer. Oftentimes clients will ask me, where should I be storing the original will? I think that you should store it with a lawyer. If your lawyer is not going to charge a fee, have them store the original. That way, if there was a fire in your home, it's not being destroyed. Oftentimes when you keep important documents at your home, they can be lost. I had a client that was in his 90s, and he had one of those safes that you can buy, like a fireproof safe, in his house, but it wasn't bolted anywhere. And so when he was 90, his house was actually broken into, and they just picked up the safe and took it, and the original will was sitting in there, and he had that will for 40 years. Luckily, he had capacity to do a new will, but if he didn't, it would have been a huge issue because he wasn't leaving everything equally to his two kids. And so it's really important that you let your executor know where you're storing it, and you want to ensure that you're keeping it in a safe spot. In addition to that, your executor is going to have to collect all information and documentation relating to your estate. So they need to know, who the family members are, what their addresses are. This is usually less of an issue where you're appointing a family member as the executor. But if you're appointing a third party or if you're appointing someone else, you really want to ensure that you're keeping a record keeping of all of your beneficiaries' information, right? Because all of those individuals are going to have to be served with an application when the executor is applying for probate. And so having all of that information written down can make things a lot easier for the executor. Your executor should know who your financial advisor is, who your lawyer is, and who your accountant is. That's really important. And I would do an introduction from now, right? Instead of just having their name on a piece of paper, maybe get them to be in contact with those three people. Any personal agreements. So if you if you're separated or if you've been divorced, having that divorce decree and separation agreement with your paperwork is really important because your executor will need to be able to access it. Income tax returns, and then any material with respect to ongoing litigation. So if you're in any sort of legal matter, it's really important that that documentation is there, and that way the executor can continue dealing with that upon your passing. So we're just going to pull up the assets and liabilities here because your executor needs to be well aware of what those are. So if you have a safety deposit box, you will want to let your executor know where that is. A lot of times clients will have private company shares, and you can have actually a secondary will that deals with those shares so that those private shares don't have to go through probate. So it'll be important to let your executor know that. And then digital assets, right? This is becoming more of a hot topic, and we don't really have legislation that's clear on digital assets. I'm sure we will in the coming years, but it's really important that your executor, one, is able to access your digital assets. So perhaps you're leaving information with respect to passwords and things like that so that they're able to access and either shut them down or transfer points and things like that. You want to be able to access your photos. Remember, crypto that can't be accessed is essentially crypto that you don't have. So it's really important that you're taking care of your digital assets. These days, a lot of lawyers will have clauses in the wills giving the executor the ability to be able to handle digital assets explicitly. So you might want to check your will, or if you're doing an update, maybe mention that to your lawyer if they don't include that provision that you want something in there. And then online travel and shopping accounts. A lot of times these things have value. And so you'll want to be able to deal with them in your will, and you will want your executor to be able to access them. And then, of course, safeguarding all of those assets. So once you're aware of what those assets are, you do have to do things like change passwords where you can, redirect mail with Canada Post. If you're getting rental, if your estate is getting rental payments and things like that, they'll have to be able to handle all of those types of payments coming in. Any bills that have to be paid, they have to handle that. So you can make life a lot easier for your executor if they know exactly what your assets are, what payments are coming in, what payments need to go out, and keep a record keeping of that. Amazon has a really useful tool where you can basically have a book where you indicate all of this information. You can find templates online as well. So that might be a good idea, right? It's called like an asset inventory. And essentially it has all of the main information you need. You take a look at it every year and update it. If your executor has this information, it really helps with that estate administration process. Oftentimes, if you have your executor acting, they have no idea what your assets are, that discovery process is taking months alone, right? So we haven't even applied for probate because we need to understand what your assets and liabilities are. And without that, we don't really have a starting point, right? I've been in situations where an executor has been appointed, they have no idea about the deceased affairs, and now we're essentially writing to every financial institution asking if the deceased has assets there, right? And it's not easy to work with these institutions where they don't have records. And so it can be quite problematic because we're waiting for them to respond and they're not planning on responding because the deceased doesn't have assets there. And so it can be really difficult, but if you have this inventory that you've created, it can make things a lot easier for the executor when they have to act. Now, I mentioned before that oftentimes whoever you've appointed as your financial power of attorney, they're usually the same person as your executor. But in a situation where they're not the same people, your executor is actually supposed to get that accounting from the attorney so that they're able to review it. Because one of the executor's jobs is to ensure that they're maximizing the estate value. So they'll want to look at that record keeping from the attorney to ensure that everything was done properly and that there was no foul play and things like that. And so that's one of the first steps as well. Any credit cards, they'll want to cancel. Things like magazine subscriptions, they'll want to cancel. They do need to file for probate. So with that, the expectation is that you're hiring a lawyer to help you with that probate application. The executor isn't responsible for completing that application themselves. There are situations where you'll see executors say, oh, I want to save the estate some money, like I'll do it myself. I don't recommend that. These court forms, it's very easy to make a mistake. And so let's say the executor decides to fill it out themselves. One, it's going to take them a long time. And two, by the time they complete the application, if they submit it and there's a simple error on there, the court's going to send that application back. And so now we've wasted months because there was an error in the application, right? And so hiring a lawyer to do it can make things a lot easier. You know that it's going to be done properly. And that way, if there's any sort of mistake or holdup, oftentimes a lawyer can work with the courthouse and just rectify the error and get it back in. And so the idea here is that you hire help when it comes to that probate application. A lot of things, most tasks the executor has to do personally, especially if they're going to take compensation for it, they shouldn't really be delegating it. But that actual probate application, the expectation is that you are retaining a lawyer to do it and that the estate is going to cover the legal fees for that. And then applying for any death benefits, so CPP, employment pension, life insurance. Again, we're here to maximize the estate value. And so those are things that they're going to have to look at. And then as far as transferring title for those estate assets, usually it's transferred to the executor first, like in trust, before it's transferred to the beneficiary. It's rarely transferred directly to the beneficiary. Now, on the slide here, we're talking about the probate fee calculation. So we talked about the probate process and why it's there, right? So the court is there to validate the will so that the executor is able to act and assets can be transferred without that institution or the lawyer having to deal with the liability. Now, the executor does not take care of any assets that fall outside of the estate. So if you have registered plans, your RSPs, RIFs, TFSAs that have designated beneficiaries, those fall outside of the estate. So they go directly to the named beneficiary. And so the executor is not responsible for those assets. Same thing where you have joint tenancy with right of survivorship. So let's say husband and wife are entitled to real property, wife passes away, the husband's automatically going to acquire that property through right of survivorship. It doesn't form part of the estate, so the executor isn't ever going to deal with that. So when we talk about this probate fee calculation, it only applies to assets that form part of the estate that the executor actually has to deal with. So in BC, and every province has different fees. So I'll give you an example. When I was in private practice, I was in Ontario, it's 1.5% there. I currently live in Alberta, and we have a flat fee of $525. So we don't do a lot of probate planning in Alberta just because of that flat fee. In BC, it's also percentage based. So you can see an estate size of less than $25,000, there's no probate fee. For the estate size between $25,000 to $50,000, it's 0.6 of 1%. And then anything over $50,000, you're looking at a 1.4% probate fee. So for the most part in BC, clients usually look to have assets fall outside of the estate so that we don't trigger this probate fee. So usually your registered plans will have a designated beneficiary. But we want to be careful here, right? So let's say we're leaving everything to a child who's 20. Maybe we don't want to name them as the beneficiary because even though it falls outside of probate, so we don't pay this 1.4% tax, maybe we don't want a 20-year-old receiving, $1 million in investments. Or same thing with joint tenancy with right of survivorship, right? A lot of times we think, okay, well, we'll add our adult child on title to our real estate so that it just goes through them for right of survivorship, but it doesn't, so we don't have to pay this 1.4% probate tax. But you have to think about the capital gains implication, right? If they own their own property, now your property becomes a capital property to them. So that capital gains implication is going to be much more significant than the 1.4% probate tax. So just a couple of things to think about there, but this is how that fee is calculated, and the executor is solely responsible for assets that form part of the estate. Other duties that they have to take care of, so paying all of the deceased personal and estate debts out of the estate, right? So they're never responsible for paying anything personally. Advertising for creditors, this is especially important and necessary if the client passes away without a will. But usually just to protect the executor, I would say it's always safe to advertise for creditors, right? That way they can come out, we can handle that before we start paying out to the beneficiaries. Filing any income tax returns, right? So especially if they're considered a US persons, there's going to be filing that's required in the US that can get quite complicated. So you want to ensure that you are taking care of all of that. And then typically before we start making payment to beneficiaries, especially those residuary beneficiaries, we want to ensure that we're getting clearance certificates from the CRA. So again, you'll probably hire an accountant to help you out with that. If there's any claim against the estate, so let's say like a dependent support claim or a claim from one of the beneficiaries, the executive's job is to remain neutral. They're supposed to follow the terms of the will. They'll have a lawyer that's representing the estate, but really you don't want to get too involved with the beneficiaries, right? You want to just be standing neutral, and it can be difficult, especially if the people who are making a claim against the estate are your siblings, but you're there to protect the estate. And then distribute specific gifts. So usually how it works is a will might give out specific gifts or cash legacies And then there's that residuary distribution, right? So if you're giving any cash amounts, like let's say $10,000 to a charity or $10,000 to a friend, that will come out first. And then you have this, big pot of money left over known as the residue, and that's usually divided in percentages. So those specific gifts are paid out first, and then whatever's left over is divided based on the percentages that you've left in your will. Other duties here. So you do have to prepare a full estate accounting for those residuary beneficiaries. So they're entitled to see every financial transaction that's taken place within the estate. And typically what's going to happen is once you get that clearance certificate from CRA, you'll prepare this accounting and you're responsible for preparing that accounting. If you hire an accountant to do it, it's going to come out of your executor's compensation, but you have this accounting prepared. You give it to the residuary beneficiaries. The idea is that they actually go to a lawyer or an accountant and they get independent advice on that. Once they're ready to sign off, they'll sign a release that you've prepared as the executor, saying that they've had the opportunity to look at the accounting, they've received that independent legal advice, they're okay with the accounting, they're satisfied with it, they're agreeable to the executor's compensation. They're going to sign what's called a receipt and release, saying we've received the check and we're releasing the executor from any liability, and then you can give them the check. So you distribute the residue of the estate to them. Now, why are you looking at keeping a detailed record keeping of everything? One, because any expenses that you've incurred, you want to ensure that you're getting reimbursed for it. And two, in order for beneficiaries to be able to determine the executor fee you're entitled to, they'll want to see everything that took place within the estate, right? And then you're going to propose an executor fee, and we'll talk a little bit more about executor compensation in the next slide, but that accounting is there to support all of that. I'll just pull up all the points here. So does an executor get paid and how does that work? So it really depends on how your executor sets it up as far as what the executor is entitled to. So I would say 90% of the wills that I've seen when I was in private practice were actually silent on executor's compensation. And I've talked to lawyers before, asking why is there no mention in the will about executor's compensation? And I think oftentimes lawyers think that if the will is silent on executor's compensation, it deters the executor from taking it, right? Whereas if it's specified in the will, then they see that and there's more reason for them to take it. But it really just depends on the executor, right? So most wills, even if they do mention executor's compensation, they'll just say that the executor can take it based on, the rules of the province. But you have a choice. If you want your executor to receive a certain amount of compensation, you can actually specify it in the will. I would be careful about putting flat fee amounts. The reason for that is you don't know what your estate size is going to be at the end of the day. So if you put a flat fee in there, you could be leaving them a really high percentage of your estate, right? But if your estate happens to grow, or you end up having a lot more in your estate and you leave a flat fee and that flat fee is too small, maybe your executor doesn't want to act, right? Because it's not worth their time. And so you want to be careful. Usually it's better to leave a percentage in there if you do want to leave a specified amount. If the will is silent or they make mention of executor's compensation, but they don't actually specify the percentage, it's capped at 5% in BC. And that's that gross value. And so most of the times I would say a judge is not going to say you're fully entitled to 5%. Usually it's around, 2 to 3%, depending on what was involved with the complexity of the estate. And we'll go through some of those factors on the next slide. But keep that in mind. So it's capped at 5%, but typically they would be entitled to 2 or 3%. Now, usually if it's silent and the executor decides that they want to get the full 5% and the beneficiary sign off on it, then there's no issue there, right? Then the executor would be entitled to 5%. But if some of the beneficiaries say, it's not worth 5%, you didn't have to do much, it was just investments and a house, why are you taking the full 5%? It wasn't that difficult to administer the estate, then they might not sign off, and then it'll go through the courts and a judge will ultimately decide how much the executor is entitled to. The other thing to keep in mind is any compensation that they're receiving from the estate is taxable income, right? So maybe they don't want to actually take compensation from the estate. So as far as the factors that the courts would look at, so the gross value of the estate, In Ontario, they look at revenue receipts as well. And then the complexity of what was involved, right? So was there anything that was really difficult? Was there a business involved? How many beneficiaries were there? Was there beneficiaries living outside of the country? Were the beneficiaries giving the executor a really hard time? Did the executor have special skills that kind of set them apart and allowed them to administer the estate? And would we have had to pay for that expertise somewhere else, but we didn't have to because we had the executor who was knowledgeable on that? The time that they've spent on those tasks. How much do they delegate out, right? So if you're delegating a lot of your tasks to other people, you shouldn't be receiving compensation, right? That should be paid out of the compensation. Things like preparing the estate accounting, receipt and releases, things like that. If you're getting a lawyer or an accountant to do it, you shouldn't be getting paid for that. And then let's say you have multiple executors appointed. So if we have two executors appointed, they're not each entitled to that percentage, right? They would share that. I think we skipped a slide here. So who should you appoint? You first of all want to appoint someone with ample time, right? So a lot of people will say, okay, I have two kids. My one son is really financially savvy. He runs a business. He has three kids, great family guy. Like, I think he would be a good choice. But then your other son maybe is retired and he doesn't have children. Just because one has a business and is a little bit more financially savvy, that doesn't mean that they're the right choice, right? If they have a business and kids and a lot going on, maybe they don't have time to make your estate a priority. Whereas your other son, who might not have a business but is retired, might have the time to do it. So you want to think about that. Someone who's willing, accessible and patient. So a lot of times you're going to be on the phone with CRA for 2 hours at a time, right? So if you're appointing someone who doesn't have the patience to do that, it's going to be difficult, right? Especially if beneficiaries are now asking for a timeline and things like that. If they're not patient, it could cause, tension between the siblings. Someone who has integrity, objectivity, and good judgment, that's obvious. Someone who's financially and administratively inclined, that's important, right? So while I say financially savvy is not everything, it's definitely still important. Someone who's familiar with the deceased affairs, right? And that's important. It can really help start that estate administration process. Now, when you're appointing a trust company, they might not necessarily be fully versed on your affairs, but again, by leaving that record keeping or providing them with some information, that can be really helpful. I've worked for a trust company before, and I know we had clients who would, send in this asset inventory every year, and they would update it, and they would ask if we had any questions or anything that we wanted to know, and that was really helpful. And then you want to appoint someone, ideally someone who's in the same province as you, just because a lot of things still have to be done in person, right? So even though we are living in a bit of a more virtual world since the pandemic, not everything can still be done virtually or with e-signatures. Oftentimes it's still face and pen to paper. And so if you have someone who's residing in the same province as you, it can be a lot easier, but you definitely want to be appointing someone who is in the same country as you, right? So CRA looks at an estate like a trust, and they say where central management and control of that trust is taking place is where that trust is resident. And so if you've appointed someone who's living in the US and they're handling everything in the US, CRA might say that because central management and control is happening in the US, it's considered a US trust. And that could open up the floodgates to like US tax implications, right? And we want to avoid that. So it's important that the person you're appointing is a resident of Canada. So who are some people that you could appoint? And I'll just pull these up here. So you could appoint a spouse or other family member. Very common to appoint your spouse as your primary executor. And for the most part, your spouse, like you're appointing them, but really probate isn't going to take place until the death of the surviving spouse, right? If all of your assets are joint between you and your spouse, then probate's not going to take place until both of you have passed away. So you'll appoint your spouse, but likely it would be your kids or somebody else who are acting. If you don't have kids, maybe you're appointing a friend. You want to be careful with that though, right? You can appoint a friend, but make sure you have backups named, because if your friend is the same age as you, they could predecease you. Perhaps they're too elderly and are unable to act. So it can be a good option, but have backups named. a business associate. So BC is a little bit strange in that you can have primary and secondary wills to avoid probate on the shares of a private corporation. But in BC particularly, you can't actually appoint the same executor under both wills. So oftentimes the people will appoint a spouse under their primary will and then will have their business associate act as executor under the secondary will. You could also appoint your lawyer or your accountant. A couple of things there. One, again, if they're the same age as you, they could predecease you. Maybe they're not in private practice anymore at the time you pass away, so they're not going to be willing to act. Maybe they're running a really busy practice, and again, your estate's put at a back burner, so they might not be the best choice. So you really want to be careful with that. And a professional is going to still take fees, right? And so it might not be ideal to appoint them instead of appointing a trust company. The trust company might be a better option. And another thing to keep in mind, so when I was in Ontario, I think I was appointed as executor under 9 people's wills, and I was really reluctant. I would say, go to a trust company, but for these 9 clients, I'd said yes. And then I moved to Alberta. So I had to call all the clients up and say, we need to make a change to your will. You will need to appoint someone else because I'm moving. And so that's the thing, right? And a lot of times the lawyer's not going to call you and say, you appointed me as executor under your will. You need to come back and make that change. So it might be safer to appoint somebody else. And then we talked about the trust companies. Again, they can be a really good option. And you can call each trust company, see who you think will best fit that role, and you can talk about compensation and see where you're comfortable, and you would sign those agreements from now, but they don't come into effect until you've passed away and the trust company is actually appointed as executor. And so you could always appoint them for now if your kids are maybe younger or you're not sure where they'll be, and then 10 years from now you go ahead and change your will and you can remove the trust company. The fees won't kick in until they actually act. And again, don't forget co-executors and co-trustees, if that's something that you're interested in. But in my opinion, I think it's more important to ensure that you have alternates named, right? A co-appointment might not be a good choice, but you want to ensure that you have backups named. And sometimes what clients will do is they'll appoint a co-relationship between the trust company and, let's say, one of their kids. And that can be a really good joint appointment, right? So the trust company is taking care of all of the work, but they're asking the child about their opinion, right? So, if your real estate agent is still working, the child can say, well, my parents always went through this real estate agent and I would like to use them. And there's no reason why the trust company would say no to that, right? So it can be a really great working relationship between a child and a trust company. And then this is just our executor checklist. We have a nice PDF version that we can send out to you, but essentially it goes through all of the estate administration tasks that a simple estate requires. And you can see that there's a number of them. And this can be a really great opportunity for you to sit down with whoever you've appointed and just confirm with them that they're willing to act based on what's required of them. And then your advisor, right? So use your advisor. They're able to really help you out with a lot of things. And they have that experience, they have that knowledge. They're able to connect you with people like us who are able to give you advice and give you those extra resources and materials where needed. So we're happy to help. And then just our standard disclaimer. So although I'm a lawyer, nothing I say in this session should be taken as legal advice. We're having a general discussion just for information purposes. And I'm happy to take any questions.
Thank you so much, Alyssa, for going through that topic with us in great detail. I'm sure we all appreciate it. Just answering a quick question in the chat, administrative wise. There will be a recording available for anyone that had to leave early or wants to go back and look at the information. And then we will be sure to send over any materials such as the executor checklist to the attendees today. I don't see any other questions in the chat. If anyone has any questions, please feel free to put them in there. If anything comes up after, we're happy to help. Just reach out and we can get you your answers. I do have a couple of questions. There might be some good talking points, Alyssa.
For sure.
So what are some common challenges that an executor typically faces?
Yeah, so I think one of the big ones is dealing with beneficiaries. So even if beneficiaries are your siblings, oftentimes they're in a really vulnerable state. There's a lot going on. Perhaps their spouses are involved and they're wanting to know what's happening with that estate administration. So that can be one of the most difficult tasks, right? You're grieving, especially if you're a child, and you've been appointed as executor, and now you're having to deal with a number of people. You're doing your best, and the beneficiaries, coming at you with questions and stuff can be quite difficult, and it can cause strain on the relationship. So that's definitely something I've seen. The other thing is the knowledge piece, right? So if this is your first time doing it, you've probably not dealt with things before. So really, grasping and getting an understanding of what's involved. You're dealing with your lawyer, they're charging fees. So you're really trying to learn as much as you can on your own. There's a really big learning curve there. Getting the proper tax and legal advice is so important. Working with an accountant who knows what they're doing. Timelines, things like that are really important. So there's a lot of work involved, a lot of shock factor. But I think the big one is the learning curve and then dealing with the beneficiaries.
Absolutely. And then how can an executor protect themselves during this process?
Yeah, for sure. So a few things. Number one is really keeping good record keeping. That's going to be huge. So every time you're dealing with a transaction within the estate, having a receipt, basically setting up a binder and a full record saying, this is the receipt, this is when the transaction took place, and doing that on a daily basis. Every time you're incurring a certain transaction, make sure that you have a record of it. That will be important. There is executor's insurance that you're able to purchase. And most of the times the will put a provision in there that allows you to do that. So if that's something that you're worried about, especially if you're acting for like someone who's not related to you, like not a parent, I would encourage you to get that executor's insurance just to protect yourselves. And usually that's paid out of the estate. So that could be something that you do. And then just working with a lawyer and accountant, right? A lot of times we're trying to save on fees, but you want to ensure that you're protecting yourself, right? So working with the people to do that. And then those receipt and releases are really important. So before you start doing a distribution to those residuary beneficiaries, ensuring that they're signing your release, confirming that they've had the opportunity to get independent legal advice and now they're releasing you of any liability is really important. And if you're not sure and you don't want to prepare it yourself, pay the lawyer to do it, right? It's going to come out of your executor's compensation, but at least you're protected.
No, that's some great advice. It's just a question that came in the chat here. Just give me 2 seconds here. So if two people are joint executors and one is more able to take care of the estate, they live closer, better access to the documents, is there any legal or financial implications to the second executor if the first one does not complete all their duties properly? Like filing deceased taxes, canceling bill payments, credit cards, all of that.
Yep, so they're both jointly liable. So if one is less involved as far as not filing things on time or not taking care of things, they're both going to be jointly liable. So it's natural, right? If one executor is living in the province, maybe they're handling more of those tasks, but any decisions do have to be made jointly. Anything that requires signing is going to require both of their signatures. And so one can't say, my sister lives in the province and she was supposed to handle majority of the work and, she didn't do it on time and it's not my responsibility because she was handling most of it. If it's a joint executorship, they both have to be doing everything jointly. So there's joint and several liability between the two of them. Or sorry, joint liability between the two of them. It won't be several in the sense that, one takes the fall. Both have to take the fall together.
Awesome. Appreciate that response. It looks like that's all the questions we have right now. If there's, like I said, if there's anything that comes up, please feel free to reach out. We can get a hold of Alyssa